Members, it's the appointed time. We have a quorum. Please take your seats. We will use the request to speak button system today. Let me first invite government officials to join us.
咁我唔逐一介紹政府。
I'm not going to read out the names of the government officials one by one. The administration has submitted a reply on issues raised at the meeting on the 5th of February this year. I believe you have all received it. The administration has also provided a response to the written submissions received and the views raised by deputations at the meeting on the 1st of March this year. I believe you have received it as well. On the 22nd of March, we received 2 other documents. I have just been notified that there are 2 other documents. The Secretariat has yet to officially received the 2 documents. So in total, there will be 3 documents. I believe you haven't received all of them yet. Once we have received the documents and submissions, we will forward them to the administration and see how we're going to handle them. Let me first invite the administration to walk us through the replies that it had provided. Members, please feel free to press the button to speak if you have any questions in relation to the administration's response. Thank you, Chairman. Like the Chairman said, one of the documents was submitted at a short notice. Before this meeting, we submitted 2 responses. The first reply is in response to issues raised at the meeting on the 5th of February, and the second reply is in response to the second meeting where deputations attended. In response to views raised by members and deputations, we provided a reply. Let me briefly walk you through the 2 replies. I will first go through the first reply. One of the questions asked by members is compensation given to minority owners. Members are particularly concerned about the sales proceeds. Members asked us to provide figures and statistics on the proceeds that went to minority owners. On minority owners' compensation, under the Land Compulsory Sale for Redevelopment Ordinance, there are different provisions that protect the interests of minority owners. First, minority owners can raise objection to compulsory sale application raised by developers, regardless of whether the lot should be redeveloped. The minority owners can also raise objections to the valuation provided by developers. After an order for sale is granted by the tribunal, it is the tribunal that set the reserve price. If both developers and minority owners both submit valuation reports, the tribunal will go through the 2 sets of reports and set a reserve price. According to the law, when the tribunal determines the reserve price, it has to take into consideration the potential redevelopment value of the properties concerned. Also, in terms of the apportionment of sale proceeds among minority owners, it is stipulated under the law, like it is said here. It is apportioned according to the existing use value of the properties concerned. In relation to statistics concerning sale proceeds, we have analyzed 165 cases, and it is found that the sale proceeds apportioned to each owner amounted to about 1.83 times the existing use value. We've also looked at 26 cases in recent years, and 60% of the minority owners in these 26 cases were able to purchase a property aged 30 or below in the same district. Under the bill, we offer one more protection to minority owners. For adjoining lot applications, the Lands Tribunal, when setting the reserve price, will have to take into consideration the higher redevelopment value given the amalgamation of adjoining lots. The second question asked by members is about building statistics of proposed designated areas. After we've set the designated areas, how many buildings are going to benefit from the compulsory sale application thresholds newly set? Well, there are 7 designated areas in the first batch. We have set 2 indicators. To become a designated area, there have to be buildings aged over 50, and there have to be at least 300 of these buildings in the designated area. Some of these buildings may be issued with mandatory building inspection scheme notices. If there are 200 buildings that are issued with such notices, and there are over 300 buildings that are aged 50 or above, they will become designated areas. For the first batch of designated areas, there are 7 of them. You can see the distribution of these areas in terms of the 2 indicators. The 7 designated areas are set out in the table here. You can see 50% and 39% in the 2 columns here, meaning that for these 7 designated areas, 50% of the buildings are aged 50 or above among all the buildings in the 7 areas. And 40% of these buildings have been issued with the mandatory building inspection scheme notices. And you can see the number or ratio compared to all buildings territory-wide, including those in non-designated areas. So you can see the percentage is high compared to that in non-designated areas. So the message we want to bring out is that these areas deserve to be specified as designated areas. So we have designated areas and non-designated areas. After we lower the application threshold, how many buildings will benefit? Well, we have to first look at this set of statistics. Territory-wide, the number of buildings aged 50 to 59, in total there are 9,600. After we lower the threshold among the 9,600 buildings, 2/3 of them, that is 6,500 of them, will benefit from the lower application threshold. Among the 6,500 buildings, if you look at the building here, some of them are situated in designated areas, so some of them are located in the non-designated areas. About 4,400 of them in designated areas, and 2,100 are in non-designated areas. It is hard for us to make an estimate how many more buildings will be redeveloped after we lower the application threshold. But to give you an idea, in the previous legislative amendment in 2010, previously there were about 6 cases per year before 2010, and afterwards there were about 28 cases per year. So the increase was significant. There were views raised by deputations, and here are some of our responses. On the application threshold for designated areas and non-designated areas, well, the first point we'd like to make is we would like to talk about our policy intent. We propose to lower the application threshold for both designated areas and non-designated areas. This is because building aging is a territory-wide phenomenon. In our papers, we have covered some statistics and figures. The pace of aging is far quicker than the redevelopment pace, so we would like to lower the application threshold to arrest urban decay. While we think that we need to lower the application threshold for compulsory sale, we would like to bring out this message. That is, there are limited resources in the private sector for redeveloping buildings. We'd like to channel the limited resources to designated areas, so we apply the 2 indicators. We focus on areas with a bigger pressing need for redevelopment. So the application threshold will be lower for designated areas compared to non-designated ones. If we compare designated areas and non-designated areas, for buildings aged 50 to 59, the difference between designated and non-designated areas, the application threshold is 70% and 80% respectively. And for those aged 60 to 69, the difference is 65% and 70% for designated and non-designated areas respectively. Well, there is a difference on the threshold between designated and non-designated areas because we want to focus the resources on designated areas. It is not an absolute scientific method. We understand that lowering the application threshold is just one of the steps that we can take. Whether a private developer would like to take forward a redevelopment project, they have their own considerations. We'd also like to point out that when we set the differences, there are things that we take into account. The highest threshold is 80%. And the lowest threshold is 65%, and in between there is only a difference of 15%. And within the 15% difference, we have to set different thresholds for buildings of different age groups. So, for some of the buildings, the threshold is higher. And this is only natural. As mentioned, among the 6,500 buildings, those that can benefit from the lower application threshold, 4,400 are situated in designated areas and 2,100 are located in non-designated areas. So buildings that will benefit from the lower application threshold or those that can benefit in non-designated areas, the number is significant. So we believe that there will be a push factor to boost the number of compulsory sale applications in non-designated areas. Now we'd like to talk about how we determine the area of the lot for adjoining lot applications. We allow for a weighted averaging arrangement to determine the threshold. And this is also to determine the percentage of ownership. With the weighted averaging arrangement, we need certain information, that is the area of the lot concerned. Currently, under the bill, we propose that applicants may submit 3 types of documents to prove the area of the lot concerned. They are government lease. Also, if undivided shares are involved, we need the relevant documents. The third type of document is the building plan approved by the buildings department. We have to clarify on one point here. The 3 types of documents mentioned should be sufficient to deal with most of the cases. That means, in most of the cases, applicants should only need to submit these 3 types of documents to the Lands Tribunal to prove the area of the lots. In case where applicants are not able to submit these 3 types of documents, it doesn't mean that the compulsory sale applicants will not be able to be processed. It just means that without these 3 types of documents to prove the area of the lots concerned, then the weighted average arrangements would not be able to be applied. Depending on the age of the buildings and the proposed threshold, the Lands Tribunal can still make a decision on the case. So in cases where applicants fail to submit the 3 types of documents, this would be the consequence. That is, the case would still be able to be handled. Why we propose these 3 types of documents? Well, the idea is that we want the Lands Tribunal to be able to handle the case and prove the area of the lots concerned in the most convenient way and the most indisputable way. Lands granted by the government involve government lease, for sure, and this is one of the 3 types of documents we propose. And if there are undivided shares, there should be documents showing that there are undivided shares. So this is the second type of document that needs to be submitted. And there must be buildings erected on the lot concerned, and there will have to be layout plans or building plans approved by the buildings department. That's why I said with these 3 types of documents, the case must be able to be handled by the Lands Tribunal. When the Lands Tribunal gets these 3 types of documents, the Lands Tribunal will look at the area of the lot shown in these 3 types of documents, and the Lands Tribunal will not have to make its own judgment or decision, and that would save time. Therefore, we propose applicants to submit these 3 types of documents. In the previous meeting, some professional bodies mentioned why the government does not accept qualified surveyors to make plans to show the accurate area of the lots concerned. We have considered this suggestion. If, however, we allow a qualified surveyor to submit a report to prove the area of the lots, to be fair to minority owners, will have to allow a chance for minority owners to submit their own report as well. And the Land Tribunal will have to make a decision after considering the reports from both parties. And there may be disputes. And this will lengthen the proceeding. This is the first point. The second point is that when the adjoining lot is not involved in the compulsory sale application, and it has nothing to do with the redevelopment project. And if we allow a professional surveyor to make an assessment of the area of the lot, and that an adjoining lot which has nothing to do with the application is involved, we will have to give a chance to the third party to raise an objection concerning the lot that has nothing to do with the application. Again, this will lengthen the proceeding, and this will run counter to the objectives of streamlining the procedure. We have tried to explain this to the professional bodies, and it looks like there are no further objections raised by the professional groups, so we may maintain the position of that the three types of documents would suffice.
Lastly, on civil servants cooperative building society scheme buildings, whether they can be included in compulsory sale. We did have such cases before, and these were approved by the Land Tribunal. Let me explain more about what the scheme is. We no longer have this scheme at this moment. This came from many years ago. At the time, the government had granted land at concessionary prices, approximately 1/3 of the market price, so eligible civil servants can build units in a cooperative building society. But the owners do not actually own the units because the building was constructed by the co-op society, while they can occupy the units. If they have to transfer the units in private market, they need to do three things. One, the co-op society has to be dissolved, and there are existing procedures for that. We have 200 odd co-op societies at the moment, and over 200 of them have been dissolved. And the land leases of the respective units will be granted after the dissolving of the co-op society. As said before, as the land was granted at concessionary prices, land premiums would have to be paid by owners in order to remove the restrictions on transfer for the units. And that is roughly how the scheme would work. If such units are involved in a compulsory sale application, these steps would have to be taken. The 3 steps. We also talked about last time how we can streamline the application procedures for compulsory sale. We have several measures proposed. One, we have been liaising with the judiciary. In future, we do want the judiciary to promulgate more rules so that stakeholders will know how to streamline the procedures. Right now, the Lands Tribunal do have some rules for mediation. Applicants are thus well informed. For example, about when to go into mediation, and if there are objections, what is the impact? We will continue to liaise with the judiciary to streamline the processes more and to promulgate more rules. We will also allocate more resources to the Lands Tribunal. After the passing of the bill in the second half, we propose to have 2 judicial positions created. And for our very last point on this slide, if a building is age 50 or above and all the minority owners have been found and they do not object to redevelopment, the requirement for which developers have to prove to the Lands Tribunal about the age and state of repair of the building can be waived in relation to compulsory sale. It is because over 80% of the past cases in which minority owners did not raise disputes on the age and state of repair of buildings. That's why, with such projections, if we can waive this requirement, we should be able to compress the process by over a year. As we plan to streamline the procedures, some concerns were raised by deputations or individuals in relation to the rights of absentee owners, whether their private property rights will be compromised. Well, because they would not get to object to the application, whether their rights will be compromised. We consider it prudent to deal with the scope of the streamlining of the procedures thus. In fact, we had taken this into consideration back when we were drafting the bill as well. We want to ensure that the private property rights of Article 6 and 105 of the Basic Law will still be protected under the bill, and we consider it to be the case. Because, as said earlier, this system does protect the rights of minority owners, as the minority owners would have the right to raise objections about the compulsory sale application, and the Lands Tribunal will play a gatekeeper role. So, for minority owners or absentee owners that have not raised objections, the Lands Tribunal would require the developer to submit a report to prove that the lot should be redeveloped. So the Lands Tribunal will continue to play a very important gatekeeper role, and thus protecting the private property rights of minority owners under Article 6 and 105 of the Basic Law. So with the streamlined procedures, if we do not cater to specifically the absentee owners, whether that will be a problem, we would say that the arrangements would still be complying with the Articles 6 and 105 of the Basic Law, because minority owners are supposed to raise the notice of no objection themselves without interference. If this is applicable to absentee owners would lose the right to raise objections to redevelopment, and they would also lose the right of them having the lands tribunal as a gatekeeper. So we consider the streamlined procedures to not be applicable to absentee owners to be appropriate. Let me also say this. Even if there are absentee owners, even if the streamlined procedures are not applicable to them, it does not mean that the compulsory sale will not go through. It's just that the applicant would have to submit a report, as I said earlier, to prove that the age and state of repair of the building makes the building suitable for redevelopment. It was also mentioned last time that in various cases, for example, when the owner has passed away, the owner has been declared bankrupt, or if a unit is owned by a company, the company has liquidated or has been dissolved, what is going to happen? Now, under the definition of the law, minority owners would include the lot owner as well as successor in title. If an owner has passed away, the individual inheriting the property would become the new minority owner, and they can participate in the compulsory sale process. For example, if there is no will, we will also have an executor. Or the will has not been fleshed out, there will be an executor. If there is no will, we'll have the official administrator or the general administrator who has been given the letters of administration. So if an owner has passed away, there will definitely be someone who can deal with the matters relating to the compulsory sale process. As for an owner that has been declared bankrupt, it would be the official receiver, the professional trustee, or the trustee that would take that role. And if a company has liquidated, it would again be either the official receiver or the liquidator. For the apportionment of the proceeds of sale, as seen here in the first point, the reserve price is determined by the court with reference to the redevelopment value of the lot. If there are adjoining lots, one should refer to the second point here. As the bill suggested, we have to consider each lot's redevelopment value, and the value will be apportioned to each lot on a pro rata basis. And then we will also make use of the existing use value. And this is an approach that we're taking at the moment.
都有提過咧，就係嗰個。
That was mentioning about the joint sale services. This is a service provided by the Urban Renewal Authority. It is to help minority owners to assemble titles to meet the application threshold to launch a compulsory sale application. We've talked to the URA, and upon the passage of the bill, the URA will review the joint sale service. That includes enhancing the service. One of the things that URA will look at is, for instance, according to the joint sale service terms, the minority owners will have to get at least 50% of the undivided shares to launch an application, and the URA would look at whether it is necessary to review the threshold for joint sales services. Thank you. We have 1 hour and 25 minutes left for today's meeting. A lot of questions will be raised, I believe, during the clause-by-clause scrutiny. I believe apart from the questions that you have raised, you have other questions that you want to raise in relation to the principle. We may also touch on the preamble of the bill. I hope we will only touch on the questions in relation to the provisions in the next meeting. So far, 7 members have pressed the button to speak. I'll give 4 minutes to each member, questions and answers inclusive. Mr. Tony Che. Thank you, Chairman. I'd like to follow up on the replies provided by the administration. The first reply is in response to issues raised at the meeting on the 5th of February. Paragraph 2C of that reply on apportioning the sale proceeds on a pro rata basis. Some ask about adverse possession. And I wonder if adverse possession would be considered when the sale proceeds are apportioned. Some buildings involved in adverse possession do not have the shares. How will you handle cases of buildings with adverse possession under compulsory sale in the future? Paragraph 7 shows some statistics which I believe are very helpful. What are the basic requirements that need to be met for a building to be determined as in a designated area? I can tell from here that over 30% of the buildings are aged 50 or above in the designated areas. In Chun Wan, there are about 23% of the buildings issued with the MBIS notice. I want to know clearly what requirements have to be met for an area to be specified as a designated area. Are there requirements concerning the density of buildings when you set a designated area? In the interest of time, I'll just ask one more question. On your reply to issues raised by deputations, it is said in the paragraph 23 that if a lot belongs to the government, how are you going to decide who are minority owners? 3 questions, Permanent Secretary. I thank Mr. Tony Che for the 3 questions. The first question is about adverse possession. That is, whether adverse possession would affect the existing use value of a property. I believe that it would not affect the existing use value of the properties concerned. when the sale proceeds are apportioned among owners according to the existing use value, the factor on adverse possession would not have an impact. We will provide supplementary information about this on real cases after this meeting. Member also mentioned about having to have clear indicators for us to specify an area to be designated area. We do have clear indicators for an area with 300 or more buildings aged 50 or above, and 200 or more buildings issued with mandatory building inspection scheme notices. They would be specified as designated areas. Chairman, I understand this. I wonder if the percentage of such buildings compared to the total number of buildings across the territory would be considered as an indicator as well. Well, currently we do not consider the ratio. We only adopt the indicator of 300 and 200 as the indicators. Currently, we have 7 designated areas in our list. Under the bill, the Secretary for Development may amend this list, and it is subject to negative vetting by the Legislative Council. That means you can remove or add more areas to the list. Is that right? Yes. Every year we will review the list. We will see whether there are areas or more areas that satisfy the requirement of 300 and 200 proposed. We'll see if there are more buildings that meet the requirements to be included or excluded from the list. We will conduct such a review every year. However, is it necessary for us to amend the list every year? It will depend on the actual situation. The third question concerns properties that have already been resumed by the government. Would the owner still be able to raise objection concerning applications for adjoining lot application? Well, would the application have to meet the 60% and 70% standard? Yes. Ms. Carmen Khan, on the question about designated areas, I raised a question about the indicators set by the administration in the first meeting of the committee. I asked about the objectivity and the level of reasonableness of the indicators set. From the PowerPoint presentation here, we can see the total number of buildings in these areas to decide whether the indicator sets are reasonable. If we look at Chun 1, the number of buildings are below 300 and 200 for the two indicators. And the percentage of such buildings account for 34.4%, and for Mongkok is about some 25%. And the Permanent Secretary just now said that the administration will simply look at the percentage. Well, now you have specified the 7 designated areas, and you designate the areas based on the OZP. So among the 150 areas set by OZPs, you have specified 7 designated areas. Does that mean For the other areas, the percentage is lower than 34.4%. That means the percentage of buildings aged 50 or above in other areas, or percentage of buildings with the inspection scheme notices, are not necessarily lower than 34.4%. Is that right? Also, riding on the question raised by Mr. Tony Che, you will only add more areas to the list instead of removing the areas from the list. Some developers may be considering taking forward a redevelopment project, and for those developers, they would not want you to remove the designated areas from the list. And on the application threshold, for buildings aged 60 to 69, can we go to that slide, please? You are not increasing the threshold for buildings aged 60 to 69 from 70 to 75. So for non-designated areas, the threshold is 70%. For designated areas, the threshold is 65%. So the difference between the threshold between designated and non-designated areas is not significant.
或者
The three questions asked would have a question that was asked by Tony Tse. Perhaps the administration can give a brief response. Yeah, your answer was on, your question was on the apportionment issue. All right, thank you, Ms. Kamen Khan, for your questions. Whether an adjustment mechanism is to be available, we did consider that. But as Ms. Kamen Khan said, for certain developers, if they are undertaking a project in a designated area, and if we are removing an area as a designated area, it may affect the developer's plan. We will take this into consideration when reviewing the provisions of the bill, of course. We did consider whether an adjustment mechanism should be available. We have considered past cases, and we think an adjustment mechanism may not be appropriate. I guess we have to strike a balance, but we'll definitely review the suggestion made by Ms. Kamen Khan. On the table, we have certain restrictions. We can only have a 15% difference. If we want to have a figure that does not have any decimals, we do not have a choice but to only have the difference between 5 and 10%. We do not have much room for adjustment in this regard. Well, unless you change the threshold, but then there may be further discussions needed. Indeed, I think we should make the difference also 10% for those that are only 5% at the moment. Well, I think the administration can consider that after the meeting. Thank you, Dr. Tik Chi-yun. Thank you, Chair. It was said by the administration that the lowering of the application threshold would be beneficial, but I think it is beneficial to the developers, but I think it is not as much for minority owners. Everyone's rights should be protected. With the threshold being lowered from 80% to 65%, that is a significant change. We should be prudent and make sure we have adequate protection for minority owners. We do want to listen more to the views of minority owners, because the minority owners who attended the meeting last time said their rights were not protected. I have 3 questions. It is said that it is the reserve price set before would be 1.83 times of the existing use value, but from what I know, only one company would participate in redevelopment, and I want to ask if it is indeed the case. If there is only one company that would participate in the compulsory sale process, would that have skewed the prices? It is also said that the administration wants the limited resources channeled to buildings in designated areas. But we have quite a lot of buildings to deal with the lowering of thresholds in both designated and non-designated areas. So I think we should limit the lowering of the application threshold for only buildings in designated areas, because I do not really see the need for lowering the threshold in non-designated areas for redevelopment. In the UK and Singapore, the compulsory sale application threshold is 80%, and they have been doing quite well in redevelopment, it seems. Have you referred to these examples to see what other approaches they have taken other than the lowering of thresholds to expedite redevelopment? Thank you. Thank you, Chair. Regarding the 3 questions raised by the member, in particular on the companies that would participate in compulsory sale, we have seen in at least 5 cases there was competition. 6 of them would have competition in the successful tendering, and there were 160 odd cases in total. 6 of them had competition. That is, there was more than one company that would have a reserve price set under competition. So there are over 100 cases that did not have any competition. Correct. I think it is reasonable, however, because the company would have to go through a lot before the compulsory sale process, for example, to obtain consent from various owners. The member did not agree that the threshold should be lowered for non-designated areas, but as I said earlier, aging buildings is a territory-wide phenomenon. And there are, as I said, 2,100 buildings that would fulfill the criteria in non-designated areas. We believe with the lowering of threshold in non-designated area, that would expedite redevelopment in urban areas. As for why the compulsory sale threshold of the UK and Singapore can be maintained at 80%, while maintaining the pace for redevelopment, I think we need further studying, but we are lowering the threshold right now because we think it would help with the collection of stakes. We want to expedite the pace of redevelopment. Chair, I do not object to redevelopment, but I think we should, exactly as the permanent secretary said, channel resources to buildings in designated areas. So we should lower only the threshold in designated areas, and then the administration would have quite strong justifications for that. Let me raise something here. The buildings in non-designated areas can still undergo compulsory sale. It's just that the threshold is higher. So for the interests of minority owners, regarding Dr. Tick's point that their rights may not be adequately protected, let me first ask the administration whether there will be a difference in protection for minority owners with the different thresholds. Thank you, Chair. When we lower the threshold, there will be more minority owners that may be involved because there will be more compulsory sale cases. And under the bill, in addition to the existing protection offered, we have administrative measures that would help minority owners. We have been liaising with the URA to set up a one-stop hub for minority owners to provide advice as well as to provide other forms of support such as legal advice and emotional counseling if necessary. And as said earlier, we will apply for funding with the Finance Committee upon the passing of the bill to implement the dedicated loan scheme with government guarantee so that we can provide minority owners with access to loan to tide over liquidity gap in handling the compulsory sale litigation. So not only do we have protection under the bill for minority owners, we will also have in place some administrative measures. So let me say this, with the lowering of the threshold, it will only expedite the pace for redevelopment in the sense that there will be more owners that may be involved in the compulsory sale process, but then there will not be any change in the level of protection for minority owners. Correct, Chair. In fact, there may be enhanced protection. Thank you. All right, thank you, Ms. Doreen Kong. I want to ask about the buildings age 60 to 70. The threshold will be lowered from 70% to 65%. I object to that, because for buildings age 60 to 69, there are 1,300 odd buildings. And taking into account the total number of buildings, that is 9,600 buildings that would fulfill the criteria, it only accounts for 15%. And it is said that for those age 70 or above, there are still 1,200 of them. So why not deal with those first? And why would you need to lower the threshold for non-designated areas? As the administration said earlier, they wanted to channel resources to buildings in designated areas. The administration said the buildings aging would be a territory-wide phenomenon, so they want to lower the threshold for non-designated areas. I do not really understand the justifications put forward the government. For example, if we have a family that would want to have their daughters married, they want to marry, for example, the first one first, then you would obviously prioritize putting together the endowment for the first daughter. But now it seems that you're putting together endowments for both daughters, and it does not help with the issue. So for majority owners, they already have, say, 40 to 60% of the stake in buildings. With the lowering of the thresholds, will they no longer have the incentive to carry out repairs for the buildings? We are also scrutinizing the other bill on building management at the moment, and we heard before that the Lands Tribunal would not approve cases where buildings are maintained really well. So there is a conflict here. I do not want the wrong message to be conveyed here. With the building that is in a bad state of repair, we should not motivate them to wait for compulsory sale. We should get them to carry out repairs as soon as possible. There is a long wait before we can undertake compulsory sales, so I think we need to send out the right message here that we should prioritize repairs. If we do not convey the right message, it may go as far as damage our reputation. So that is what I want to point out. Thank you.
Permanent Secretary. I thank member for the questions. When we set the application threshold, we took into consideration this. We think that the application threshold for buildings that are younger should be lower. For buildings within the same age group, we want to achieve this. We hope that resources can be channeled to designated areas with more aged buildings and buildings issued with inspection scheme notices. So we want to direct the resources to the designated areas. That's how we came up with the proposed application thresholds. Buildings that are older, they should have a lower application threshold. And for other buildings within the same age group, we want developers to prioritize old buildings in designated areas. So old buildings in designated areas, they will have lower application threshold. During our first meeting, we gave a briefing about this bill to members, and we stressed that compulsory sale is just one of the measures that we are going to put into place to speed up redevelopment. Another approach that we're going to take is to ensure maintenance and repair works to be conducted in old buildings. We have a series of measures that we will implement to help minority owners, especially minority owners of buildings issued with inspection scheme notices. We offer support and help them to get subsidies under the OPP 2.0 scheme. And we teach them how to get surveyors to inspect their buildings. So we agree that we should adopt a multi-pronged approach to speed up redevelopment. Mr. Chek Ho-fung. I'm pleased that the government is providing us with some statistics. I think we have to take into consideration the actual situation when we consider the threshold. I've talked to some engineers and they said that buildings built in the 1960s are of poor quality, but those built in the 1990s, they are structurally safe. So we have to take into account our needs when we adjust the threshold. So most of the buildings we see now, they are about 60 years of age. So with this bill, we can ensure that all buildings with poorer structures can be dealt with in a reasonable way. Of course, we have to take into consideration building structures when we decide whether to take forward a redevelopment. For developers, they look at the profitability and they look at the plot ratio when they decide the profitability. I believe most of the plot ratios, for buildings built in the past, the plot ratio has been maximized. And for developers, when they decide the profitability, they look at plot ratio. I understand that in Yao Chim Mong district, you allow the interchangeability or transfer of plot ratio between buildings. But this measure is not implemented in other districts. By simply lowering the application threshold, I doubt how effective your policy would be in terms of speeding up redevelopment. In your PowerPoint presentation, you mentioned that minority owners will benefit from adjoining lot applications because redevelopment potential will be greater in adjoining lot application. We all know that when developers acquire properties, they engage agents to do that. And they do it lot by lot to lower the compensation they have to pay to owners. And this will, in turn, exploit minority owners. How are you going to protect the interests of minority owners if developers, they acquire buildings lot by lot instead of amalgamating the lots? Permanent Secretary. The first question is about plot ratio. As we have stressed, compulsory sale application is just one way to facilitate redevelopment. Plot ratio adjustment may be one way to help speed up redevelopment. Currently, in Yao Chim Mong district, we allow transfer of plot ratios, and we have just kick-started the measure, and it's too early for us to determine the effectiveness of the policy. In Chunwan, URA is currently conducting a large-scale study. URA will look at how many more infrastructures will be needed in the district to enhance the plot ratio. To enhance plot ratio, we have to conduct feasibility study. We cannot simply enhance the plot ratio. We have to look at transport infrastructure. We have to look at utilities, for instance, facilities that deal with sewage or water supplies. So URA is currently conducting a study in Chun Wan to see how much plot ratio can be enhanced, and this will give us an opportunity to raise the plot ratio, and this may facilitate redevelopment within the Chun Wan district. That's the first point. Secondly, member asked whether developers, in order to avoid sharing the sale proceeds with minority owners in large-scale redevelopment projects, and instead launch compulsory sale in individual lots. Well, there isn't a way for us to prevent developers from doing so. However, there is incentive that we provide to developers to launch adjoining lot applications. That is, we allow for weighted averaging arrangements. Say for adjoining lots, developers may acquire more properties, and in other lot, the developers may acquire fewer properties or units. And we allow for the weighted averaging arrangements for developers to launch adjoining lots applications. So we are encouraging developers to do so by proposing the weighted averaging arrangements. Mr. Bill Tang? I think there is a need for us to speed up urban renewal and fix old buildings. The cost of maintenance and repair is high for old minority owners. I'm referring to owner-occupiers. They have to face a dilemma because they have to take money out of their own pockets to conduct maintenance and repair works for their buildings. And this is difficult for them. $20 or $30 ago, owners might be willing to take money out of their own pockets because they wanted to stay in that building. But now, minority owners are getting old, buildings are getting old. Owners may not be able to afford the cost for maintenance and repair works. There were measures put into place to avoid bid rigging, and Competition Commission also plays a role. All these help give peace of mind to minority owners. The administration has to know what legal rights minority owners are entitled to. You have to tell the entire community, including district councillors or members of this council, how you're going to help owners. You have to hold seminars, you have to hold talks. We're seeing some breakthroughs here. For instance, you're going to specify designated areas, you're imposing different application thresholds for different areas, and you're also streamlining the procedures. So there are many changes that we're going to see with these proposed measures. For buildings aged 60 or 70, we want to ensure minority owners get their benefits when they sell their properties. say the application threshold is lowered, the owners may regret when they sell their properties. How can we minimize loss of minority owners with the differences of application thresholds? The second question I want to ask is about absentee owners. Under the bill, for owners with their whereabouts known, the application procedure can be streamlined. How do you define whether the owner's whereabouts are known to avoid people from abusing the system? What about in cases in which owners show up for a while and then disappear? So how can you stipulate clearly that what you mean by whereabouts are known?
第一個問題呢，就係
Permanent Secretary. Thank you. The member asked 2 questions. One on how to ensure owners know about their interests. So when we set up the dedicated office with the URA, we will first identify all owners affected by the compulsory sale, and we will hold free seminars to tell them about their rights, and should they raise objections, what they have to do, and what protection they would be offered under the law, and what professional services are available. We will also encourage them to make use of mediation services instead of going into litigation. For minority owners, especially those who are elderly, if they have to go into litigation, it can be quite burdensome on them, both financially and emotionally. So we will first have a free seminar, as I said, for all the owners affected. We will have professionals in different fields, the technical and legal fields, for example, to tell them, the owners, about what they should do. As for absentee owners, as the members said, we are also concerned about absentee owners showing up at certain points in time during the compulsory sale process. We do want to make sure the rights of absentee owners are still protected, which is why we said that the streamlined procedures should not be made applicable to absentee owners. Because, as I said earlier, we have to ensure that the right of absentee owners to raise objections will still be available. For absentee owners, if they are indeed absentee owners in compulsory sale processes, as I said earlier, it does not affect the developer this much. They can still go through with the compulsory sale. It's just that they have to prove that the age and state of repair of the building would warrant redevelopment. Thank you, Ms. Dory Lee. I am also concerned about protection to be offered to minority owners. It is said that in the 160 odd cases of compulsory sale before, the existing use value would be 1.83 times, and the reserve price will be set as such. I don't know if it is high or a low figure, because you would also take into consideration the redevelopment value. Often minority owners think that the redevelopment value assigned to them would be quite low. From the paper, it is said that 1.83 times of the existing use value should be quite high. But I do not see any evidence at the moment to support that justification or support that claim. So I want to ask if this figure is reasonable. With the further lowering of the application threshold, is there a mechanism to ensure that reasonable redevelopment value will be allocated to minority owners? Because if there is no effective allocation, minority owners may not be entitled to the benefits that are reaped. We need to ensure the system would protect minority owners in the sense that they would get their part in the benefits to be reaped from compulsory sale. I also want to see a summary of the 160 odd past compulsory sale cases. We may not have specific figures on how much the owners actually got, but I guess we can tell from the final price. I want to have these figures before I decide on my stance to take. Thank you. Permanent Secretary, thank you for the members' questions. 1.83 times of the existing use value would be the general figure, and in the last 3 or 4 lines we wanted to say in particular that for these few years there are 26 cases that were successful tendering for compulsory sale, and the owners managed to seek new flats in the district, and over 60% of them could find or could purchase flats age 30 or below in the same district. You only talked about the age, but do you have the figure on the size of the units? I believe the units would be of comparable sizes as the units that they have sold under compulsory sale. As for what the member said about minority owners reaping the redevelopment value, the reserve price is set by the Lands Tribunal. And when the Lands Tribunal set the reserve price, not only will they refer to the price offered by the developer, but the minority owners can also suggest a price, but the minority owners may not know that they can do that, which is why we will have the dedicated office in future to inform minority owners of their right to suggest a price if they are not satisfied with the valuation report provided by the developer. So, for example, when a developer suggests that a building should be redeveloped and an owner is made aware of that, they can go to the dedicated office in future, and the staff of the office will provide them with advice to make the decision. They may also play a mediator role. In the unfortunate event that the case would have to go into litigation, then we can also help them with that. And we also have a dedicated loan scheme with government guarantee that would be made available to minority owners upon the passing of the bill, so that they can get access to a loan which then can then make use of such funds to obtain valuation services. And regarding past cases, over 60% of the cases, minority owners will not dispute the reserve price. But I think it's because minority owners did not know that they could do that. I understand the members' concern. We will definitely do better in future, in the sense that we would want to provide sound advice to minority owners, and the Lands Tribunal would continue to play a gatekeeper role. Can you give us more details about this, because we only have general information here at the moment? Excuse me. Perhaps I can provide some supplementary information. Even when owners do not object to the reserve price, the Lands Tribunal would play a gatekeeper role. And when we looked at past cases, 20 cases in which the owners did not dispute the reserve price, but the Lands Tribunal made adjustments to the reserve price in these 20 cases. And the members of the Land Tribunal would conduct site visits to inspect the condition of the buildings and then set the reserve price. So, as I said, the Lands Tribunal would act as a gatekeeper, and that would offer some protection to minority owners as well. Ms. Story Lee asked for information about whether the benefits for redevelopment are indeed reaped by minority owners as well. But then with this surplus, there is often a time lag factor at play. So I think the administration will have to take that into consideration when providing such information. Thank you. Dr. So Chang-Wing. Thank you, Chair. In relation to the lowering of the application thresholds, I believe there are two pros. One, it would expedite urban renewal. That is a definite benefit. We have heard the discussions between the trade and the government before. It is said that the lowering of the thresholds would help increase supply of housing upon redevelopment. This would tackle the pressing need for housing in Hong Kong. But as other members said, with the incentive offered, that is a huge factor as well. The reserve price is to be set by the Lands Tribunal. But then I think by then it would be too late. As you may know, for an old district, for an aged building, whether a developer has the incentive to acquire the building, whether owners are willing to go into compulsory sale, all these factors would come into the consideration of the developer. So we may not necessarily have enough incentives for the developers to actually acquire buildings that we want them to acquire. I think the plot ratio measure that the Development Bureau has would actually be more effective. For example, for the 13 streets in To Kwa Wan, this redevelopment scale is of course quite large, and they have used up the plot ratio almost. They only have approximately less than 10% left. The developer would of course take that into consideration. The developer would have to consider the potential profit that redevelopment would bring about, and they would consider that when they propose a price for acquisition. So I do appreciate to a certain extent the protection offered to minority owners under the bill and the mechanisms proposed. But I think the government has to consider the incentives to be offered so as to make sure that developers would indeed be interested. And as Ms. Doreen Kong said, we have to make sure owners would still carry out repairs of buildings. Of course, it is beneficial to encourage compulsory sale, but then the process would take long, as we all know. And some people may not be able to afford the wait. Thank you.
個意見啦，或者
There are two comments made by Dr. So Chun Wing. Administration, please be brief. I thank Dr. So for the two comments. We've noted the comment about the plot ratio. As mentioned, we are currently conducting a large-scale study in Chun Wan. If we can figure out the details on what to do with the infrastructure, and if we can enhance the plot ratio, I believe this would facilitate redevelopment of the area. The current mechanism allows developers to make planning application to enhance plot ratio. I agree with what Dr. So said. We have to ensure maintenance and repair works are carried out in old buildings. This is what we are going to actively take forward in the future. 3 members are waiting to speak for the first round, and 2 members have pressed the button to speak for the second round. I'm going to draw the line here. For those who would like to speak, please press the button as soon as possible. Mr. Lam Sang Kung. Thank you, Chairman. Members and deputations have raised concerns about interests of minority owners. Recently, there are 2 motion debates about long-term building development as well as public and private housing development in Hong Kong. I want to know whether this bill applies to public housing units or HOS units that have been sold. My second question concerns the interests of minority owners. We members have to balance the interests of different parties. I'd like to give the administration a chance to talk about the actual benefits of lowering compulsory sale application threshold for the redevelopment of old buildings in Hong Kong. 2 questions, Permanent Secretary. I thank member for the questions. The first question is about public housing units sold and HOS units sold. Would they be subject to the compulsory sale regime? Well, if I understand correctly, they would be subject to the new compulsory sale regime. However, there is certain difficulty. From what I understand, some public housing units are being rented to tenants and some have been sold. And it might not be appropriate if we include public housing units into the compulsory sale regime. For HOS units, we have to take into consideration payment of premium. I believe both public housing units as well as HOS units can be subject to compulsory sale regime, but there would be difficulty in terms of actual operation. Plot ratio for PRH units are used up, and we have to take into consideration whether developers would benefit from redeveloping public housing units. The second question is about benefits that we can see by lowering the compulsory application threshold. In the last legislative amendment, after we've lowered the application threshold, we've seen more compulsory sale application cases. We hope that by lowering the application threshold, we can speed up redevelopment. In terms of enhancing housing supply, we think redevelopment projects would not contribute much to the housing supply. In the past 10 years, we saw 40,000 private housing units redeveloped. It is not a big number. And for developers, those redevelopment projects took a long time. And so it wasn't a huge incentive for developers to redevelop the private housing estates or private housing units. And this is exactly why we're proposing to lower the application threshold. It's not the case that we would expect a significant increase of application cases after we've lowered the threshold, but we believe there would be more motivation for private sector to redevelop old buildings. On the first question asked by Mr. Lam about whether the compulsory sale regime would be applicable to public housing units and HOS units, you said the regime would apply to public housing units and HOS units. We talked about cooperative housing. Well, a premium has to be paid under the regime. So I believe the administration will have to make it clear the applicability of the compulsory resale regime on HOS units and public housing units. Mr. Dennis Leung. We are concerned about the aging of buildings and buildings getting dilapidated. We want to improve people's living environment. I think lowering the application threshold can give an incentive to private developers to redevelop old buildings. However, for minority owners, we are concerned how we can offer help to them and how their interests can be protected. Maintenance and repair works have not been conducted in a lot of the old buildings. It is not because minority owners are unwilling to see repair works and maintenance works to be carried out. It is because there are objections raised by majority owners. Majority owners with more undivided shares, they object to the maintenance and repair works. And when private developers propose to acquire their properties, it is not because minority owners are unwilling to sell their properties. It is because the prices offered are too low. And with the low prices offered, minority owners aren't able to relocate to another property of a similar size or of a similar value. So minority owners are met with all these challenges. By lowering the application threshold, minority owners may face even greater challenges. I wonder what measures the administration can put into place to further protect the interests of minority owners. The administration mentioned that the Lands Tribunal can act as the gatekeeper. However, the problem is that developers offer very low prices. And that the Lands Tribunal will have to set a reserve price because the prices offered are too low by the developers. With the one-stop services offered by developers and professionals, minority owners cannot provide a valuation that reflect accurately the value of their properties. What measures can be put into place to further protect the interests of minority owners? Can there be a standard to the prices offered by developers so that it would be easier for minority owners to reach a consensus with developers in terms of the value of their properties so that an auction does not have to be held? The government may be able to lend money to minority owners, but minority owners may still lose the case when they get to the Lands Tribunal, so we have to think about how to protect their rights. Thank you. Permanent Secretary, I agree with what the member said. Member mentioned that we should avoid litigations. Can we have the developers and minority owners reach a consensus before they proceed with litigations? Well, this is about mediation. We want to better promote our mediation services to both developers and minority owners. Chairman, perhaps we can provide a written reply on this. We can, in the reply, elaborate on what measures we're going to put into place to protect the interests of minority owners. We will also, in the submission, include measures that we will take to ensure that minority owners will be able to enjoy a reasonable sale proceed. We'll also talk about the services that we're going to provide in the new centers to be set up under the URA. That includes services such as valuation services. I welcome this proposal by the administration. I believe members would welcome further reply from the administration as well. Members have mentioned about different pain points. In your reply, it would be great if you can address those pain points and services that you're going to provide to minority owners to protect them. Ms. Judy Chen. Thank you, Chairman. Members in general understand why the administration is proposing to lower the application thresholds because buildings are aging rapidly in Hong Kong and we want to protect the properties as well as the safety of owners. However, we have some concerns. We have to be more forward-looking. We have to think about what impacts the new measures are going to cost to minority owners. Permanent Secretary has stressed time and again that the Lands Tribunal can serve as a gatekeeper. The paper has set out some statistics to explain why the administration is going to specify the 7 designated areas and how many buildings will be affected with the lowered application threshold. However, I do want to have more information about previous cases handled by the Lands Tribunal. The Lands Tribunal haven't dealt with a lot of cases. Before the previous legislative amendment, there were 6 cases per year. And after 2010, after the legislative amendment, there were some 20 cases per year. So we haven't seen a lot of cases being handled by the Lands Tribunal. I want to know the number of cases that have been dismissed by the Lands Tribunal and the reasons behind. Will the administration be able to provide more information in this regard before the next meeting? Secondly, I've said in the URA before, I support the urban renewal projects implemented by the URA. There are lots of professionals working in the URA. However, from the perspective of minority owners, the URA may involve in compulsory sale in the future. Understand that a dedicated office will be set up under the URA to offer help to minority owners to help them go through the entire procedure. Will there be ways to ensure that the dedicated office will act independently so that it won't give people the impression that there will be conflicts of interest? Thank you.
Thank you, Ms. Chen, for your questions. We can provide supplementary information after the meeting, but let me first say this now. The Lands Tribunal has rejected 5 compulsory sale applications so far, 3 of them in which the threshold has not been reached. For the remaining ones, the Lands Tribunal has doubts as to the age and state of repair of the building, whether it warrants redevelopment. That's why the applications have been rejected. We can, of course, provide the details after the meeting for these cases. If the URA is not able to resume all the units, the government will make use of the Land Resumption Ordinance to help acquire the remaining units. The URA as a representative of the government in the compulsory sale process, how they can better protect minority owners in future. It is something that we will deal with. The URA, we need to make sure the dedicated office to be set up is neutral in the sense that it will remain independent in the process, or at least it will signify so to the public. We will also set some rules for staff members of the office. When the staff members introduce people to the services offered by the dedicated office, they should only provide information to the owners. They should not encourage owners to make use of certain services. We will definitely make sure measures are put in place to ensure the operations of the dedicated office are smooth. Due to time constraints, I'll only assign 3 minutes for each of the members speaking for the second round. Ms. Kamen Khan. Thank you, Chair, for giving the opportunity to speak for a second time. I understand that with this bill, they would lower the thresholds of compulsory sale. They will also have streamlined procedures for compulsory sale. But then it does not mean that the administration does not want owners to carry out repairs, and this is being dealt with by another bill. I think the public should know that these two issues are dealt with by different departments, so one does not affect another. That is, with these amendments encouraging the compulsory sale process, it does not mean that it would discourage people from carrying out repairs. It should not convey the message that people should wait for a compulsory sale instead of carrying out repairs. And I appreciate the administration providing more information to ensure there is good coordination between the two areas. During the last meeting, some views that were raised on the fact that we should exclude absentee owners, and because the process should be expedited, the administration should include absentee owners in the scope of the streamlined procedures. And I appreciate the government's stance that they will have the streamlined procedures continue to not be applicable to absentee owners. I think it is a prudent approach. And I also appreciate the fact that with the streamlined procedures applied, if applicable, that would really compress the time frame for the compulsory sale process, that is for over 12 months. So if the streamlined procedures are not applicable, the developer would still, as the administration said, have to provide a report that would prove that the age and state of repair of the building would warrant redevelopment. And again, I think that is a very prudent approach to take, and that would offer adequate protection to minority owners. Thank you. Thank you. I think the administration should indeed provide supplementary information, as the member mentioned, and the rest are suggestions or comments made by the member. Next, Mr. Tankapu. Thank you. Expediting redevelopment is definitely beneficial, but we have to ensure adequate protection is offered to minority owners. I observed that before it would be very hard for minority owners to apply for legal aid for a case to be dealt with in the lands tribunal. If it is a dispute between an owner and a tenant, it is possible, and it would often be the case that a tenant would apply for legal aid. Of course, we do not want people to go into litigation often, but is it possible for the administration to provide some sort of legal aid for minority owners to protect their own interests should the case go into litigation? I understand that people would often go to the legal aid department, but before they would face difficulties. Is it possible that you can have the legal aid department expand their scope, or you can provide some other form of support to minority owners? We, of course, want minority owners to not be forced into undergoing compulsory sale. They should be participating in it actively. Thank you. Thank you, Mr. Tang, for your comments. We did consider the point, but in the end we chose not to include these kinds of cases in the legal aid scheme. It does not mean we do not want to protect minority owners. Let me put it this way. When we go into the hearing stage for minority owners, they would have to think about, one, whether the building should be redeveloped, and two, whether they would have a different opinion in relation to the valuation. And we believe we can provide support to minority owners at this stage in the form of a dedicated loan scheme, so that we can provide minority owners with access to funds to perhaps engage professionals to provide them with advice. It may be legal or surveyors, professionals. When we have a compulsory sale case, if the expenses are reasonable for the minority owner to pay, in the end, if the case is won by minority owners, these costs would be awarded by the court to the minority owner. And that's why we think the problem is with whether the owner can tide over the liquidity gap in between. So we think the dedicated loan scheme would be beneficial to minority owners, and it would help them to tide over the liquidity gap in handling the compulsory sale litigation, and we think this approach is a reasonable one to take. Thank you, colleagues. Our discussions today would need some supplementary information to be provided by the administration, and I think we need a response from the administration to the legal advisor's letter as well. I hope that these will be ready by the next meeting. The next meeting is to be held on 8th of April between 8:30 and 10:30 in the morning, Mr. Rincon. Yes. You have any other business to raise? No. It is just that I want to look at clause 3.2 and 3.8. There are some complex concepts involved. So if we are to go into clause by clause examination at the next meeting, will the administration to provide a PowerPoint presentation with examples to illustrate the procedures so as to facilitate members' understanding? Thank you. That is a good idea, and we will have the administration consider that. Thank you. This is the end of the meeting.